Thank you. Thank you ever so much for that. Right, the next question is around the changes to fire and rehire. Will local people in local authorities responsible for decisions around direct payment funding be brought up to speed with these changes so they know the implication on direct payment users if they decide to reduce funding that would mean the employer has to change the terms of their PA contract? I'm not sure. Any
I can, I don't know. I can say something on that. I think, I hope so. We certainly at ILG, we do everything we can to spread awareness. Rachel and I have a newsletter that we'll be sending out to local authorities with updates precisely for this reason. Really, we have, ILG support obviously have a remit to advise. Um, Anybody who's employing PAs who has access to them, they're one of the main legal advice providers. Um, we know full well that the advice we give is only as good as the support that person's going to get from their local authority or from the organisation their local authority commissions. So we spend a lot of our time attending meetings and the appropriate networks to try and ensure that exactly that people are aware of it, and that they are aware of the resource that needs to go into it so that you in turn access timely information, support, resource to adapt and change to the employment legislation landscape. Because without it, then you are also always put on the back foot. So we do everything we can. Again, just spreading awareness in this meeting, Jade, is doing part of that job. There's lots of people in the meeting here who will be picking this up and have different hats on. So yes, I hope, and we'll do everything we can to keep spreading the word. Certainly.
Thank you. Okay, next question is, when a PA has worked for a client for over 2 years and when the direct payment of the client stops, i.e. the client passes away, the PA can claim for redundancy payment. However, many insurance companies only provide a package that covers a small proportion of maximum statutory redundancy pay. For example, in a case a PA has worked 5 years, the insurance would only cover less than half of the redundancy payment. I would like to know if you have any opinions on how to upload employment rights in these cases, please.
Yeah, I could talk about that, and Rachel might want to say something on top of it. But what I can tell you about that is, so the liability to pay redundancy sits with the employer. So you are liable in employment law. However, if you look at, to use the Adult Social Care Act as an example, a direct payment must be sufficient to enable you to meet any employer on costs, including redundancy. So that's explicit in the statutory guidance to the Care Act, and the equivalent actually in Scotland, Wales and Northern Ireland. So while the liability sits with you, the employer, you cannot be left without the appropriate funding to meet your redundancy costs. Now, some local authorities do interpret that slightly differently, and we've seen evidence that you are sometimes kind of told to go to your insurer. Now, local authorities can insist that you pay for an insurance policy that will, in all likelihood, if the terms and conditions of that policy are met, contribute to the cost of the redundancy. But if for whatever reason that the limits of that insurance policy don't meet the entire redundancy cost, or the terms and conditions aren't met, then that responsibility isn't taken away from the funding body. The funding body has to make sure the direct payment is sufficient to meet any employer on costs that you suffer, or you are liable for, I should say, as a result of the direct payment, unless you've misused funds and you've used too many hours and there's some element to it that they're pointing to say that that's why the bill is X or Y so high. And that's really important. So it's always about, is my direct payment sufficient? And you might say, well, in my local authorities clawed back lots of money every time they do a review, and it would have been sufficient but for that. That's down to the local authorities' kind of management of the funds. And what's in your account isn't what's important. If there isn't enough in the account, they should be topping up and making sure you can pay it. It's okay for them to say, check with your insurer first, get that contribution in. But if there's a shortfall, it should never come from your pocket or from your estate, if in the situation that somebody's passed away.
Thank you. Rachel, did you want to add anything to that, or Daniel? Daniel, you'd like to...
Yeah, just from our support service point of view, we've actually just on the point David mentioned there about redundancy and being advised by the local authority to go to the insurer first to see what they will pay out, obviously depending on the policy. And we've gone through a few of those recently in our service where we've had to get what we can from the insurer and then obviously then go back to the local authority if further funds are required. So it does, generally speaking, doesn't always happen smoothly, but it does eventually work out. I would say it just can be local authority dependent, shall we say, as I'm sure we all know, as to how that journey can go.
Brilliant, thank you. Any last points on that? Should we move on to the next question? Okay, so the next one is, can I do a freelance by invitation setup for specific bodies of work to help me prepare for a benefits appeal, deal with bureaucratic matters, set up a computer system with disability software to act on an as and when basis from a pool of 2 or 3 people, choosing the best person for the task as and when is needed? I am autistic and multiply neurodivergent, affecting me in my ability to assimilate a lot of information or organise my thoughts for more complex things. The council is agreeable to it and even suggested they signed off a declaration of understanding for me to do it through an individual service fund. But is this legally problematic? So I guess are you legally allowed to pick a PA for your work for a specific task? Is there any issue with selecting specific PAs that you know will respond best to that particular task? I think that kind of is what it boils down to.
Well, all in all, of course, during the recruitment process, you're able to ensure that you're recruiting somebody to meet your needs. And that may well take different skill sets. You know, you may want to see, for example, somebody who is quite a sociable, bubbly, outgoing kind of a person would be very well suited to do the kind of PA work where it's out and about in the community. Somebody who perhaps is a little calmer, more empathetic and caring generally would be great to look after somebody who needs support in the home for personal care work. I'm obviously picking on very obvious generalizations here to demonstrate the point that, of course, you can recruit somebody to suit your needs. The key that I would say to always be mindful of is not to discriminate whilst you're doing that, which can in and of itself be kind of challenging.
I've just asked a clarifying question because I'm not sure if she means during recruitment or once she's recruited and has a pool of PAs, can she pick within that pool for specific tasks? I wasn't sure either way which was meant. I've just asked her, so we might come back to that when she's had a chance to answer, if that's okay. I'll move on to the next question, but we'll come back to that one. PAs paid significantly over minimum wage will be responsible for their own tax. They are offered work, but there's no obligation to say yes. I'm not sure if I copied that whole question actually, because I'm not sure that makes sense or if I've missed something there. I'll go through the questions in a second and see if I can find that one. Sorry. And then Brett asked a question about proof of, well, in his case, an example of death of a close relative. So for in terms of meeting the policy around bereavement and that kind of thing, will any kind of proof be required within the law, or is that up to the employer to lay that out within the contract?
I suspect that it won't be provided for in the regulations. It's certainly not provided for in the current regulations that deal with parental bereavement leave. They haven't done it. So unlike when an employee is going on an antenatal appointment during her pregnancy, there is a requirement in those regulations that says an employer can request the evidence. But no, there isn't anything in these sets of regulations at the moment for bereavement leave. In addition to having lost a child, it can also be during the term of the pregnancy when mum is further on down the line. It would be I appreciate the need for record keeping, but it feels a little heartless. I suspect the government haven't had the gumption to determine how that should happen in the regulations when fundamentally this is about support your workforce. at what point does a death certificate come through, for example, when what we're talking about is the need to take that time off immediately. Death certificate takes a while to come through, so asking for evidence is a rather awkward thing. I suspect the law will not define it and not require it at all. But, you know, we will keep people posted as and when regulations come through with these wider rights that are being introduced.
Thank you. This next question is around, is it all carers? And I assume this is relating to the new regulations coming in. And what about PAs trained by professional trainers? As I found out, our insurance is void immediately when a professional trains us, and we have to train carers or our PAs. Would insurance be void in that case? This person's from Northern Ireland, so I don't know if there's a difference here, but one assumes PAs and carers are not normally entitled to have training of some kind.
Typical train, as far as I understand it, your everyday PA doesn't require the training, and most insurance products aren't going to put an employer under an obligation to have given them training. I think the only policy that I'm familiar with that would require the PA to have had training is the personal health budget ones. David, are you able to just elaborate a little bit on that, on the way that the policy operates and the need for nursing training?
Yes, I am. Yes, so we have Mark-Based Limited have a standard home employment policy which would be applicable to most direct payment recipients employing PAs, and that is primarily an employer's liability policy. So it protects your liability in regard to if your employee is injured while working for you, and the public liability protects you if you are liable because somebody else is injured as a result of that work going on between you and your PA, or your PA damages property while working for you, etc. We have a healthcare incarnation of the policy. So home employment with, how I say we, Mark Bates, have a healthcare incarnation of the policy. What that does is it extends the public liability in the event that the PA injures you or the person in receipt of the support. And specifically if it protects you in the event that they're performing a healthcare or clinical task. But in order for that cover to be enforced, that you are required by the terms of the policy for your PAs to have been trained, to have had clinical training. So they have to have written evidence that they've been trained by a medically, an appropriately trained person, whether that's a district nurse or equivalent, in order for the cover to work. So it might be that they're referring to that, Jade, I don't know.
David, she's just clarified that she's with Fish Insurance and her son needs oxygen and CPAP.
Okay. Well, Fish, I know that Fish have a similar situation. What Fish do for their healthcare policy is they would encourage the PAs to be covered by their PA policy that does effectively the same thing, but I can't talk about their terms and conditions because although I did work for Fish a long time ago, it was a long time ago, so I'm much more familiar with Mark-based policies.
Thank you.
I'd say she should definitely contact them if she's not sure and she wants to be clear on what the insurance cover is, because it will be a combination of what she's told by the health board in Northern Ireland and her insurer.
Brilliant. Thank you. Right, we've still got quite a few questions left, so I'm going to try and whiz through some of these. I would like to know what should happen to an employee or self-employed contractor's pay in this circumstance, which is when the PA is infectious or potentially infectious, and the client asks them not to come in due to the risk to themselves as they're immunocompromised, but the PA is saying they feel well enough to work. Does the PA have a right to be paid? Does this hinge on whether the PA is genuinely able to work or not, i.e. whether they're too unwell to work? And how should this be dealt with by care agencies? I currently have a care agency who says they wouldn't pay their staff sick if they are well enough to work but infectious. But if I as a client insist, then it's up to you and you need to pay them. What's the legal stance?
Okay, well, I can certainly tackle the employment law side of things. I don't know if somebody else who's more familiar with the way care agencies operate could tackle that. But from an employment law perspective, question number one is that worker a true employee with a fixed pattern of work? You know, myself, I work Monday to Friday, 9 to 5. I have the right to those hours. So are we talking about somebody who's working that kind of a fixed pattern of work, or are we talking about a 0 hours worker? So if they are genuinely casual, then that obligation to pay may not currently exist under the current law. But yes, hang on. Let's put aside a casual worker. Let's now focus on somebody who is required to work those days. They have a right to work those days. And suddenly an employer is saying, oh, hang on a minute, I don't want you coming in when you've got a cold. Now, the basic things to keep in mind. First thing is that typically reporting of sick, reporting of them not being fit for work is the duty of the employee. It is not for the employer to determine in its typical process, and certainly when we're looking at SSP regulations. So you would normally expect a declaration of that from the worker, and otherwise the employer expects them to attend. Now, of course, we recognise that some employers, people in receipt of support, have particular sensitivities. You know, I've gone so far as to writing policies for employers in the past to say that workers can't even come in with deodorant on. You know, literally any smell can really upset their chest. So there's all sorts of reasons why an employer would not be comfortable being exposed to a virus. Does that make the worker unfit for work? Well, typically not. If I have a cold and come into the office, tough, I'm going to spread it around, but I can get on with my job. In this situation, then, what an employer should do, I would argue that the answer to the question is yes, you should pay if you're asking them not to attend work, unless you have been proactive and followed this practical step, which is to include a clause in the contract of employment that allows you to make the determination for yourself. But that is a contractual clause. And when applying that clause, you must do so reasonably. Now, we looked at this very carefully, of course, during COVID, because it was a particular concern for everybody at that time. And so we started to include these clauses, but we did say be reasonable in doing so. If we come outside of the world of direct payments and individual employers, and you think about something where there is a very high risk factor, pilots flying a plane, for example, would the airline want to leave it down to the discretion of the pilot as to whether or not his mental health was sufficient, or whether or not he was under the influence of alcohol? They, of course, under those circumstances, would give themselves the right to make the decision. Individual employees can do the same, but just make sure that you've got the right wording, you've taken advice, and that you've implemented it into the contract correctly.
Thank you. I just want to go back to the question about choosing from the pool of PAs, as there's been further information. So this lady's already recruited her PAs, and they are people in need of my focus is these people are casual, in need of a variable employment contract, or can it simply be a separate contract for each of the main bodies of work? For example, setting up a computer system for disability software and helping them figure out how to use it, treating them like a freelancer, basically. So it's more about like dividing the work available and how to put a contract to that work.
It sounds to me like the person asking the question could really do with talking to somebody so it can be fully understood. I think it sounds like quite an involved question, and I think needs a little bit of unpicking. But one of the things, there's two things I want to say is that, yes, of course, you can pick and choose. If you have got people who are genuinely 0 hours, yes, you can pick and choose who you want, because there's no obligation on you to give any of them work anyway. But another point that might be worth noting, particularly when we're thinking about the changes that are coming in with the Employment Rights Act, the wording is very specific to say that where you have given work previously, do you remember I mentioned that you might have to give guaranteed hours in the next period? It's very specific to say that is going to apply if you have somebody on a 0 hours arrangement and coupled with a main contract. So let me explain that to you very carefully. I can have a contract of employment now with my employer to do my Monday to Friday 9 to 5:30. My employer could also employ me to do on a 0 hours contract, so I have a separate contract with the same employer, but to just be called upon to do a weekend event once in a blue moon. Okay, what the Employment Rights Bill is doing is saying, well, given that you've got that main contract there, Rachel, albeit this one's aside, you need to consider the two together. So it's linking the two and creating obligations for the 0 hours contract anyway. It's not one, it's literally taking away any opportunity for employers to avoid the obligations. I hope that makes some sort of sense, and if it's I hope it's answered the question to some extent, but I do think this person could do with speaking to their legal helpline and unravelling all of that a little bit more.
Thank you. We've only got a couple of minutes left, so I'm going to ask one last question, and then if it's okay, there's a few other questions that we haven't got to. If I could email it to the panel to get some kind of response, and then we'll put it on the website. So the last question is, how likely is it that HMRC would prosecute or enforce serious consequences on an individual disabled client who is found to be an employer when using apparently self-employed PAs? So I guess it's when they shouldn't be, or deemed to not be.
I imagine prosecution is going to be unlikely, but will you suffer the penalty? Absolutely. I would be very surprised if the status of this of employers as individual employers would impact. You're facing the same legal obligations as any other employer, business or otherwise. But I think one of the things I would like to add to this is not just about HMRC and the tax side of things, where employers are also running the risk in having failed to appropriately assess somebody's employment status, is also in the other rights you may have missed: the right to statutory redundancy payment, the right to bring an unfair dismissal claim, and critically, the right to paid annual leave. That's 5.6 weeks of annual leave every single year. And if an employer has misjudged the status, then there is quite a tail on that. It could end up quite excessive. So it's not just about HMRC. Think about employment law rights and what kind of claims could arise from the employee themselves.
Thank you. Does anyone want to add anything to that last question? There's been one final question. There's others that we haven't, we still have got to get to, which I'm going to email out and put on our website. But I just thought it was an interesting question, which is, why are we, as in PA employers, treated as full employers with HMRC as we are not a profit-making business? I know it's something David and I have spoken about a lot. Not that I think we shouldn't be counted as employers as such, but more the difficulty of PA employers utilizing some of these rights whilst managing our own issues. It's more that difficulty. So I just didn't know if you had any last thoughts on that before we close the session.
I don't know, Jade. It's a big one. I'd love to talk about it more. I think it's about the rights, isn't it, of PAs? And it's. I think social care, direct payments is where social care meets employment rights, and we've heard a lot about that today, actually. And I think it's really difficult sometimes to marry up the rights of workers, if we imagine ourselves in the PA's shoes, as it is with individuals trying to get the best out of the adult social care system, which is limited and creaking and doesn't do a great job of it. So I think it's systemic, and it's not good enough to scapegoat the employer group as much as it's not the employee group. We need to look up and say, well, where's this coming from? Why haven't we got the resource and the support to do this properly? Because with the resource and support to pay people properly and actually get help, it would be a lot easier. So I think we need to just be collective and stick together and acknowledge that it is difficult, but it's still for a good purpose, and we can keep fighting together.
Thank you. Thank you ever so much. I just want to thank, well, Rachel in particular, for your brilliant and informative session. David, for your fantastic session. I know you didn't get to cover as much as we would have liked, and then to Daniel for being on the panel. And it's not easy answering these questions off the cuff like this without time to think. It really is a skill within itself. So thank you so much. And thank you so much for everyone for attending. I know 2 hours is a long time to give up when you've got your own stuff going on. So we really do appreciate you coming along. So thank you ever so much. Sorry.
So sorry, can I just say, I've just added into the chat for anyone who hasn't seen it, some good news, which was the consent order from a judicial review proceedings recently, which were about somebody who did fight the system a little bit around the way their direct payment was monitored unfairly, and they were forced to try and reduce somebody's wages. So just as a good news story, there's many of you would have seen it already, but it's well worth a read if you haven't seen it. Sorry, just wanted to get that.
No, we also posted that on the Facebook group because it really is an interesting piece, and it is nice to see sometimes a judge actually upholding our rights and fighting back for us, which should be the case all the time, but sadly it's not always happening. So do have a look at that piece of legislation. It's, well, not legislation, sorry, result. It's really, really interesting. But thank you so much, everyone. I've already put the links to our next event. So we've got our disability related expenses event coming up. We've got a peer support session and one on the Care Act and wellbeing, which I think will be really interesting. A lot of what we're talking about is the fact that wellbeing hasn't been put into your care plan. All the stuff that makes us a person, our hobbies, our interests, that's where that should come into it. So please do look at that session. I think it's really good. Everything's on the website for you to look at and book. But yeah, thank you ever so much, and I hope to see you next time.
Thank you.
Thanks, everyone.